So your case isn't getting dismissed at preliminary hearing. Does that mean everything is over? Not even close. Hi everyone, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. So I'm going to talk about another type of preliminary hearing strategy. I call it the long game. Other people might call it something different, but sometimes we have a case where I go to my client and I say, listen, there is no legal basis, unfortunately, for a judge to just dismiss the case at preliminary hearing because unfortunately, the prosecutor only has to prove this much of their case, really. They only have to prove that there's probable or sufficient cause to hold your case over. They only have to prove that it's worth potentially putting in front of a jury, not that you actually are guilty. Assuming that all the DA's witnesses are telling the truth, assuming every part of their evidence is to be believed, does it actually make you guilty of the crime? The answer is yes. Well, the judge is not going to dismiss your case at preliminary hearing, but by virtue of doing the preliminary hearing, you might be doing yourself a favor, depending on the case. Because when you force the DA to bring their witnesses out there, you expose them to question. And when you do that, you and your lawyer get to ask them questions and really highlight weaknesses in the case. Generally speaking, the more serious the charges are, the more useful this strategy is. In a homicide case, in a sexual assault case, or even in some other cases that are maybe less serious, but the factual issues are there. Like, it's enough to get the case held over for court, but there may be other issues that are worth exploring in terms of identification or the circumstantial evidence of my client's guilt. Is there actually a claim of self-defense, for example, in an assault trial? A preliminary hearing is useful for exploring these things and maybe demonstrating to the DA, hey, you might have gotten your case moved on past the preliminary hearing, but now that you've heard everything publicly, do you really want to go to the trouble of taking this to trial? And if the case goes to trial, well, now I have a transcript of all of the things these witnesses have said already that I can use at a later proceeding. It's totally useful. It's important to know that as you're sitting through your preliminary hearing, you're hearing a lot of bad things being said about you. You're being identified as having committed a crime. You're hearing the judge say there's sufficient cause that you did something. It's really emotionally exhausting. But again, I use the phrase long game for a reason. Get through the preliminary hearing with your lawyer in this situation and let them flesh out the issues that need to be fleshed out. Where are the weaknesses in identifying you as the actual doer? Is there like a claim of self-defense or other justification? Do these witnesses have motive to lie that's being kind of dragged out? Did some of the witnesses maybe get caught giving a side eye to some family members supporting people in the gallery? I've seen that one before too. All these things are useful for a preliminary hearing to flesh out, and they're not worth giving up on just because you think the judge is going to hold the case to answer and make it move on to the next stage. So don't put all your eggs in one basket. Even though the case is not going to get dismissed at a preliminary hearing, there might be another approach to it. And that's where this long game strategy comes in.